Welcome to Mindset Mental Health News and Information. I am your host, James Curtis. On today's show,
most places are not guilty, not guilty by reason of insanity. And then we have something called guilty but mentally ill in many jurisdictions.
a little late on picking up that track. Let's do that one more time.
4 possible verdicts in most places are not guilty, not guilty by reason of insanity. And then we have something called guilty but mentally ill in many jurisdictions.
That is the voice of law professor Jane Campbell Moriarty out of Duquesne University. She is not only a law professor, but she also focuses on the areas of behavioral health and neuroscience where they intersect and come together with the law. Our topic today is the insanity plea. Does it work? Does it serve victims? Does it serve defendants? Does it serve either very well? Is this a system and an idea that is indeed broken? My guest on today's show, we're going to have a snippet from Professor Moriarty, more from her in the coming weeks as we revisit the verdicts and the outcome of the so-called American Sniper trial. That was the trial where Eddie Ray Routh was found guilty in the murders of Chad Littlefield and Chris Kyle, and the upcoming jury trial of James Holmes. He is the individual charged in the killing of 12 people, injuring 70 in the July 20th, 2012 theater shooting, the Batman movie theater shooting in Aurora, Colorado. But first, this news from the Mindset Report, the most comprehensive source on the web for mental health news and information. You can find the Mindset Report on the web at mindsetreport.com. From Harvard Health, the Supreme Court is hearing arguments in a case that could threaten the viability of the Affordable Care Act. Lawyers from both sides, the Obama administration, as well as the plaintiffs in this case, backed by members of the Republican Congress, are challenging that law. It will obviously have far-reaching impacts not only on physical health issues, but mental health care. From the New York Times, psychiatric drug use has been cited in a federal study as being overused in the care of older Americans with Alzheimer's disease, primarily when they are in the care of living care and daycare facilities, board and care facilities. That use is being highly discouraged and is currently under investigation. Another item with respect to Alzheimer's issues, a protein appears to have been found by scientists, this from Time magazine at time.com, for the first time, evidence of the protein found in the Alzheimer's disease called an amyloid in the brains of individuals as young as 20 years old. You can find these complete stories and more at the Mindset Report on the web at mindsetreport.com. We've got a lot to cover today and just a little bit of time to do it. We're going to be back in just a moment with our main story. My guests on today's show, we're going to hear a little bit from Professor Moriarty from Duquesne University, Lisa Bloom, who is an attorney and a contributor for the Today Show as a legal analyst, is going to give us a summary of the trial that happened, the so-called American Sniper trial of Eddie Ray Routh in Texas. And I have a conversation with the attorney who represented Andrea Yates. You'll remember her from the 2001 killings of her 5 children, found guilty, then found not guilty on a retrial, not by reason of insanity. I talked to her attorney, have an extensive conversation. One thing I want to bring your attention to by way of news is a project that has to do with fighting the stigma that young women and women really of all ages face. There's a project on the web. It's in the middle of a crowdfunding campaign. They've made their goal for their campaign, but you can still support it. It's a great project. It is called the Unslut Project. You can find it on the web at unslutproject.com. We'll be back in just a moment. Welcome back to Mindset, Mental Health News and Information. I am your host, James Curtis. On today's show, we're dealing with the insanity defense. Does it work? How does it work? Who does it benefit? I have a ton of information to get to and to get through. I talked to a number of individuals who study this area. The first one we're going to visit is Jane Campbell Moriarty. She is a professor that you heard from at the top of the show, Duquesne University. I asked her sort of an overarching question about really the functionality, the viability, the workability of what we call the insanity defense. Here's what she had to say. Would you agree that while it may be an oversimplification, that at its base, the criminal justice system, as it relates to the insanity defense, or as it relates certainly to dealing with people who have a mental illness, and act under the influence of that mental illness, our system just doesn't work very well?
Yeah, you're right. It doesn't work very well. We have three possible verdicts. There's a not guilty. Four possible verdicts in most places. A not guilty, a guilty, not guilty by reason of insanity, and then we have something called guilty but mentally ill in many jurisdictions, which doesn't mean much other than the jury finds this person to be guilty of the crime but suffering from mental illness. In terms of going to prison, it doesn't affect anything. They still are sentenced. They still go to prison as if they had been found guilty. Theoretically, they will get some mental health treatment in jail. But we see juries sometimes compromising on that verdict. The problem is, what we're really not grasping here, I think, in allowing the guilty but mentally ill verdict as well, is that there is a mental element required for crime, right? You have to intend to kill somebody. You have to act in some jurisdictions and some degrees of murder with malice. And you have to have the mens rea to commit the crime. One of the hard pieces about mental illness as a defense is that juries are unsure about what to do with that, and which is why this guilty but mentally ill verdict has a lot of appeal. As wrapping up, right, in response to your overarching question, I do think this is an enormously complicated problem for the justice system. I don't think it's one we really have fully figured out how to handle yet, and I do think it needs consistent and further attention. Professor Jane Campbell Moriarty, Duquesne University law professor, who also focuses on the intersection of criminal law and neuroscience as well as behavioral health. We're going to hear more from Professor Moriarty in the coming weeks. Now we go to my conversation with Lisa Bloom. Lisa Bloom is an attorney, a friend of mine. We hosted a show together on the now defunct Court TV. We covered a trial involving a woman named Andrea Yates. We talk about that trial. I talk about that trial with Lisa Bloom and a more recent verdict out of Texas, the same state where Andrea Yates was tried, found guilty initially, and then found not guilty.
of the so-called American Sniper trial. That is the trial of Eddie Ray Routh, charged and found guilty in the deaths of Chad Littlefield and Chris Kyle. My guest is Lisa Bloom. She is, among other things, a friend of mine, the founding and managing partner of the Bloom Firm, a general practice law firm that handles family law, civil and criminal matters, and the Today Show's legal analyst and appears all over the network, including the NBC Nightly News. The idea of the insanity defense has come to the forefront yet again with a number of trials that have been talked about, featured, ongoing across the nation. Boston Marathon trial, the Batman movie theater shooting, and the so-called American Sniper trial, where Eddie Ray Routh was convicted just last week in the murders of Chris Kyle and Chad Littlefield. You monitored that trial. You've done a number of reports on that trial. I want to focus in on the idea of the insanity plea in general and how it played out in that case. But before we dive into that, give us an overview of your impressions of the case and particularly of the defense and its presentation.
Well, it's such a sad case. It was not a whodunit. So we knew from the beginning that Eddie Ray Routh was the killer. There was no doubt about it. The defense didn't deny it. He went to a shooting range with Chris Kyle and his friend Chad Littlefield, and Littlefield and Kyle took him there because they were helping veterans who had problems, who had physical or mental disabilities. They took them out to the shooting range because most of them liked it and they found it very therapeutic. And so, the sad, poignant part of the case that they were there to help him on that day. And Eddie Ray Routh turned the gun on the other two men and shot and killed them. And then he took Chris Kyle's truck and he fled. And so the only question in the trial was his state of mind. Was he both severely mentally ill? That part I think most people agreed that he was. But then the second prong of the insanity defense was what was at issue, such that so severely mentally ill that he could not tell the difference between right and wrong at the time of the shooting. And that's the part the prosecution said, yes, he may have been mentally ill, yes, he may have been strange, but he knew right from wrong, he knew what he did was wrong, and therefore the insanity defense does not apply, and therefore you should convict him. And the jury agreed with that, and he was convicted.
Now, with respect to the idea of his mental state at the time, there seems to be a bit of a disconnect. The idea that someone can indeed be mentally ill, indeed, as you just stated, the prosecution didn't dispute whether or not this individual, Eddie Ray Routh, was indeed mentally ill. The issue, as far as the law is concerned, in many states, including Texas, is could he know, or could he tell the difference between right and wrong? Did he indeed know at the time that what he was doing was wrong? That's a pretty high burden for any defense team to try to meet.
It's a very high burden. It's very, very difficult. And this trial took place in Stephenville, Texas, which is a small town where Chris Kyle is a hero, a huge hero. I don't know if you saw the film American Sniper. I saw it. I liked the film a lot, but there's been a lot of controversy nationwide about whether really Chris Kyle was a hero, whether he killed people in his days as a sniper that he didn't have to kill. But, there's no controversy about that film in Stephenville, Texas. He is a hero. There's a Chris Kyle Day. Now, before the shooting, there was a Chris Kyle Day. They sell Chris Kyle T-shirts and hats. So he's a real hero there. And what disturbed me after the verdict of guilty was so many people from that community saying, this was justice. Hooray, we got justice. The family felt it was justice. Everybody seemed to feel that justice was a guilty verdict and that a not guilty by reason of insanity would be an unjust verdict. And I really didn't hear any voices explaining why we have an insanity defense, why we don't hold mentally ill people to the same legal standard as everybody else. And in my opinion, the man was clearly so severely mentally ill at the time of the shooting that he did not know right from wrong. He had no motive to kill these two men. He was babbling and rambling about pigs and wolves. It made no sense at all when he was caught. And later on, when he's in a police interrogation, which was videotaped, he's just rambling on and on. In fact, when he read his Miranda rights, I don't think he was mentally capable of waiving his Miranda rights. He's asked a couple of times if he understands and waives his rights. He basically didn't answer. And then the police officer just keeps going. So, and then the police officer says to him, did you know what you did was wrong? He says, yes, sir. Just like he says, yes, sir, to just about everything the police officer asked him. To me, that's not the same thing as a confession that he really did know right from wrong. I just think the man was so mentally ill and delusional, and it's very, very sad. Of course, it's horrific that he took 2 lives. But if the insanity defense does not apply to him, I don't know who it applies to.
You and I, in our Court TV days, talked about, discussed, analyzed another Texas case, Andrea Yates, where this woman, she drowned her 5 children. She was put on trial for drowning 3 of them, initially found guilty, then retried, found not guilty by reason of insanity. The same arguments were made. That is, she knew it was wrong to kill. She was arguably her defense asserted she was trying to save them from Satan. Are there parallels at all there? Is there anything to be learned from one result versus the other?
Well, in Andrea Yates, initially she was found guilty and then went on appeal. She was retried and then she was found not guilty by reason of insanity. And she remains to date in a psychiatric facility, which is where people go when they're found not guilty by reason of insanity. They're not just set free on the street, which I think is a common misperception. I think, of course, people who are dangerous, mentally ill or otherwise, need to be kept away from the general population. We all agree with that. The only question is, should somebody like Eddie Ray Routh or Andrea Yates, should they be in a mental facility where they can get treatment, or should they be in the general prison population where they're so often victimized and sexually assaulted and bullied by the guards? And it's just a horrible place to put a mentally ill person. So Andrea Yates, there's a lot of similarity. One difference, though, is I think a lot of people felt in that case the only reason a mother would drown her 5 beautiful little children is because she's mentally ill. Just so we can understand it. And so I think people were more open to an insanity defense in that case. But, in the Chris Kyle shooting case, I would say the same thing. The only reason why he would shoot these 2 men who were trying to help him is because of mental illness. He had no other motive. They didn't have an argument. He wasn't trying to rob them. He had no other motive to kill them.
Well, I'm not asking about your comment about whether this jury did a good job, bad job, understood or didn't understand. Is there anything systematic that we can take away from this result that when Lisa Bloom is president of the criminal justice system,
when is that going to come?
That would be very cool, by the way. We would all be better off for that. Lisa Bloom is president and controller of the criminal justice system. What might we change systematically as a country as we deal with these types of issues to achieve what some might call a fairer result?
Well, if you can expand my title to, Queen of the United States, I would first of all start with better mental health treatment for people like Eddie Ray Routh, so it would never come to the criminal justice system because he wouldn't have killed 2 people to begin with. So, the backstory of this trial is that his mother was desperate to get him treatment, and we hear this story over and over again, and she just couldn't do it. And she couldn't get it. And so she ultimately reached out to Chris Kyle for this, veterans helping veterans thing. But it wasn't anything like a psychiatric hospital, which is where he should have been. And he'd been in and out of a couple. But as you know, it's very hard to keep people in unless they're a danger to themselves or others. And this man, in retrospect, obviously was a danger, but people didn't see it at the time, even though he was threatening to kill himself and threatening to kill people. People can't get their loved ones mental health treatment. That's the real big underlying social problem.
We're going to leave that interview of my conversation with Lisa Bloom right there. You can pick up the balance of that interview on the podcast later on after the program has finished. Now we turn to my conversation with, speaking of Andrea Yates, the woman who drowned her 5 children back in 2001, the individual who represented her. My guest is George Parnham. He is a criminal defense attorney in Texas. Mr. Parnham is best known throughout the country, perhaps, for his representation of Andrea Yates. She is the woman who infamously drowned her 5 children. The defense boiled down to her pleading not guilty by reason of insanity. Mr. Parham, thank you so much for joining me here on Mindset. I'd like you to go ahead and set the stage for us. When a defendant pleads not guilty by reason of insanity, what does that really mean, and what kind of position does that put the defendant in with respect to the court?
Sure. The defense has the burden of proof in virtually every jurisdiction that has an insanity defense, and the burden in Texas is by preponderance of the evidence. The standard in Texas is very archaic. It basically says that an individual must be suffering from a severe mental disease and or defect, and underscore the word severe, that results in the individual not knowing what he or she is doing is wrong. There is no definition of what the word know means that goes to a jury, nor is there a definition of what the word wrong means that goes to a jury. The state can stipulate that an individual is severely mentally ill, but still knew what he or she was doing was wrong. And that puts a tremendous burden on the defense to overcome that second prong of the insanity standard in Texas. The problem is that in bifurcating this standard, one ignores the fact there are certain mental illnesses. They carry with it a psychotic delusion, a delusion that is so fixed that no amount of objective circumstances to the contrary of the delusion can change the individual's mind. That's the world in which the individual lives. And that delusion permeates the thought processes of the individual. In other words, the word no has to be taken into context with the illness that the individual is suffering. I may, for instance, have a delusion that aliens are going to attack me from my neighbor's house. I go out and I do what otherwise would be rather irrational acts. I fill my car up with gas. I go get concrete. I pay for it by my credit card, and my purpose is to lay a air strip in my backyard so that the friendly aliens can come down and help me. Now, this sounds preposterous, but I see comparable examples basically every day in my office. Today was no exception. The rationality of these what appear to be normal acts are all done for all the wrong reason, and that is to basically fulfill this delusion and protect myself from the aliens coming across the yard. That's the problem that is utmost in convincing juries that there are mental illnesses that dictate the thought process, and for instance, when it comes to the word no, or in believing what you're doing is absolutely the right thing to do. To give you an example, another example, I could tap Andrea on the shoulder when she's in the process of drowning her children and say, Andrea, don't you know that it's illegal in the state of Texas to drown your children? And she would turn her head back to me and say, I'm aware of that, Mr. Parham, but don't you know that I'm saving their souls? I'm doing what is best for them, because Satan that lives within me, and that's actually a part of her real delusion, Satan lives within me will drag my children down to the fires of hell. They'll burn for all eternity unless I take their lives when they're innocent, at an innocent age. And that's what occurred. Now, can an individual or should an individual be judged by a jury with the objective standard out of Webster's dictionary of the word no when placed upon the mindset of the, in this case, the mother who thought that it was the best thing to do for her children? That's one of the unfortunate problems that our insanity standard carries with it. There are common denominators of insanity virtually appear in all of the states that have an insanity standard. And those common denominators are the severity of a mental illness that causes one either not to appreciate the nature of their acts, or if they do appreciate the nature of the acts, do not appreciate the wrongfulness of those acts. That is obviously not all with the insanity standard in the state of Texas. We don't have the word appreciate. Those are the common denominators, and one must present information to a jury and it would be very helpful that the individual has previously had mental health problems. I always look for any ulterior motive that could be suggested by a prosecution as the reason for the act that lands the person in front of a jury. We have such things as spousal revenge. Boyfriend doesn't want children, insurance issues. I'm not naive to the point that I don't discount the fact that there are mothers and individuals that take the lives of other people in a set of circumstances that beg the question, was he or she out of her mind? If there are ulterior motives viable, then that's very difficult for a defense attorney to overcome. Susan Smith, South Carolina, she had a boyfriend issue, and she was depressed. Those are the areas of common denominators that permeate the insanity standards throughout. We've got a federal insanity standard that unfortunately changes the burden of proof from preponderance to clear and convincing. In other words, the defense attorney must put forth evidence and that is clear and convincing to establish an insanity defense. The prosecution then can come back and basically demonstrate that the individual is in fact sane, legally sane, to rebut the insanity defense as put forth by the defense. In any event, we know that less than 1% of all cases have the insanity defense as the defense, and a very small percentage of that 1% end up being successful. Nevertheless, the insanity defense is perceived by the public as being a way out. In other words, if you don't have anything to work with, try insanity. Well, I don't ascribe to that notion at all. I look very carefully at cases, and I think it does the insanity defense a disservice if attorneys use the defense solely for the purpose of defending an individual when there's nothing else left, and that's unfortunate.
Does the insanity defense have, put perhaps overly simply, an image problem, and that is what you alluded to a moment ago? It's perceived that it's sort of the last bastion of defenses. If you don't have anything else, then throw up an insanity plea, and the idea that you can have a mental illness, you can be acting as a result of that mental illness, still know that in terms of society, it's wrong, but still be compelled by your mental illness to commit an otherwise immoral or illegal act. Do I have that right?
Right, and let me kind of address that to a degree. I think that there is a hurdle that one must negotiate, and that hurdle is the issue of mental illness in the mind of the public. I often have questions about the reality of mental illness, the stigma of mental illness. Individuals on jury panels, I've heard many times in the past, well, I just don't believe mental illness is real. Now, that has happened, and it's in this day and time. It's I shake my head and I wonder, where has that person been in the last 20 years? In any event, it begs the whole issue, and your suggestion is right on. That an individual can be mentally ill, yet nevertheless be aware of what he or she is doing is wrong, or that society would determine that those actions were wrong. I think you have to couple that with this whole thought process, the type of mental illness that's going on, the delusion. If the person is psychotic, they live in a different world than we live. They do things for different reasons. They have different goals. It's not so far fetched to think that as we speak right now, it's 12 o'clock midnight, and I am talking to President Obama, and you convinced me that no. Just look outside, the sun is shining, and you are you, and we're doing an interview. Despite the objective evidence, I still believe that it's midnight and that I'm talking to the president. Now, I think that it is grossly unfair to impose upon the mindset of that person the objectivity of an otherwise rational individual who sees the actions of the person and makes a determination that that person knew what he or she was doing was wrong, or did not, or in fact appreciated the wrongfulness of their act. There's an instruction, for instance, in the state of New York that goes to a jury, if requested, about knowledge, and the instruction contains the word surface knowledge. As an example, an individual can have various degrees of knowledge. One can have, for instance, if I'm a child in parochial school, I memorize a prayer, I may be able to recite verbatim the content of that prayer, yet not know or appreciate what certain words mean. Likewise, with the child that goes to school and takes an English course, and here we have Walt Whitman, and he memorizes a particular poem, or he's not going to necessarily appreciate what is beyond the word. And unfortunately, in Texas, we don't have such an instruction. But I fully recognize how difficult it is for the public to grasp a defense and to accept that defense when there are cases, for instance, the American Sniper, where the court permitted the jury panel to view the movie and then slapped a gag order on all participants. Well, I just think that just cemented the ultimate fate that Ralph ended up receiving, life without parole. You've got a jury panel that aware, if they don't see the movie, they're still aware of the character of this, the American Sniper, and as he's perceived as a hero. And how do you offset that when you have someone who takes the life of two individuals, one of which was the American Sniper? That's just a horrible uphill burden for a defense lawyer to climb.
Where do you start with jurors? You mentioned a moment ago that you've had jurors tell you that they don't even believe that there is any such thing as mental illness. Where do you start with talking to jurors about mental illness as it applies to your client?
Yeah, and that's a good point. I'd like to lead up to the ultimate answer. When I have an individual that I've been retained to represent, that person may be incarcerated, in all probability is incarcerated, and if the objective evidence that we've uncovered, for instance, medical records, etc., that coupled with the nature of the act itself, for instance, in Andrew's case, mother taking the life of a child, that's Madonna and child, the image that we hold most dear, that's crashed to the ground. Nobody can really understand how a mother who gives birth and gives life to a child takes the life of that child. I make certain that I get a evaluator as quickly as possible down to the jail with a video camera, and I videotape the evaluation, and I do that because if the individual has not been on medication, that person will be on medication, and there will be a physical manifestation of that person's mental illness. So we need to capture that for use in the future before a jury. We capture that for experts that will interview in the future that person. They'll see that video, and they'll understand that there is this physical manifestation of the mental illness. Where do I start with juries when we talk about it? I think that one of the issues that is as tangible as possible is to have the jury understand that they must view the actions and the mindset of the person that's performing those actions through the eyes of the person on trial. And it's just like self-defense from the standpoint of the actor. You view the actions of the person that is on trial through the eyes of that individual. And then you talk about various terms, schizophrenia, schizoaffective, bipolar, whatever the illness may be. And you talk in terms of for instance, a delusion, person psychotic. I always take out the DSM, and I have charts with the various illnesses that pertain to my client on trial, and you get a jury, as we did in the second Yates case, that accepts the reality of mental illness and accepts the fact that you have to judge the person through the eyes of the individual seated at counsel table. In the first Yates case, we had a death-qualified jury. All it takes in Texas for a death-qualified jury to sit in judgment of a woman who has taken the life of a child is for that individual on that jury to say, well, politically I'm against the death penalty. I don't believe in the death penalty. I'm morally opposed to the death penalty. But I guess in certain circumstances I could impose the death penalty. That person's qualified to sit on that jury. And unfortunately, and this is kind of a sideline, but unfortunately, what happens to women that end up taking the life of a child because of postpartum psychosis. The reality of that psychosis is that there are two choices, either death by injection in the state of Texas or life without parole. And we have nothing in the entire United States that takes into account an individual who is suffering from a postpartum issue and maims or hurts or takes the life of a child as a result of that illness. We've got the insanity defense, but we know, as we previously discussed, that that's a very difficult uphill case to make. We were successful in the second trial, and I have to add an anecdote, if I may. Barry was out 3 days, and there's one buzzer. I always hang around the courthouse. I can't think of anything else. I'm afraid to break the karma at the jury deliberation, right? So I got to stay close. But a buzzer went off, and then the jury wanted to see pictures of the kids, not the autopsy photographs, not the crime scene photographs, not the gruesome picture of Noah in the tub, but the kids in good times, the kids at birthday parties, the kids, at holiday season. And we had introduced a number of those photographs, and the first thought was, maybe they bought the state's position again, and going to Victor. And about 30 minutes later, there were two buzzers, and that meant that the jury had reached a verdict. And the verdict was announced not guilty by reason of insanity by Judge Hill twice. Only Andrea stood trial for 2 of the 5 deaths. The state was going to hold out the other 3. The jury asked us to come back to the jury room. We did. There were several jurors that were crying, some of whom had been crying. And I asked the question, you asked for the photographs, and the jury foreman said that, we owed it to those kids to spend 2 minutes over each child's memory in silence. And that jury did. And that's one of the most powerful moments that I've ever experienced in 46 years of practice.
Wow.
They got the message, because it's all about kids. I mean, it's all about the children, That's why we go forward with this Yates Children's Memorial Fund, trying to educate screeners to go out to the WIC clinics, and we got a bill passed at the legislature that mandates that hospitals have new parents sign a disclaimer that they have been informed of postpartum issues and what the indicators are. So the legacy of those kids has been to prevent tragedies like the one that occurred on June the 20th, 2001 at 942 Beachcomber, the home of Rusty and Andrea and Noah, John, Paul, Luke, and Mary Yates. There were 5 children and 1 mother who were victims that day of mental illness. Mental illness was the real culprit. And so, the legacy of these kids may have lessened the occurrences of postpartum issues taking the life of a child. Every child deserves to be raised by a mother as free from mental illness as possible. I remember going down to the house. It took me a long time to get the courage to go, and I went and took a psychiatrist with me, and took one of the team members with me. and Rusty, the husband, gave us a tour of the house. I remember driving up to the house, and the dog was barking, and I kept thinking, maybe the dog thinks the kids are home. And the trikes were all lined up, in perfect order out in the backyard. And I go through the homeschooling room, and there was a little card attached to the bulletin board, had been undisturbed since the deaths of the kids, and the card was from Noah. And it said, "Please, God, help my mother get better." Kids recognized that their mom was suffering.
George Parnham represented Andrea Yates in both trials. That's our show for this week. Next week, from Duquesne University law professor Jane Campbell Moriarty, we conclude our interview. Should the determination of criminal trial sanity simply be left to the judge? Until next week, for Mindset